Christal Miranda, and I'm trying to help the deputies out so they won't have to bring people back. Court is calling 2023 CR 5938, State of Texas versus Christal Miranda. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
For the defendant.
Are you Christal Miranda?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Christal Miguel Miranda who was placed on deferred adjudication in 2023 CR 5938 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram, on August 17th, 2023 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1. On or about the 5th day of November, 2023 in Bexar County, Texas, the defendant, Christal Miguel Miranda, committed the offense of criminal trespass in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 4. In Bexar County, Texas, the defendant, Christal Miguel Miranda, did then and there fail to report to the supervision officer as directed for the months of September and October of 2023 in violation of condition number 4.
How do you plead to that? True or not true?
No.
Your Honor, we waive the other violations alleged in the motion.
Any objection?
No objection.
Did you understand by pleading true to violations 1 and 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1 and 4?
Yes.
Court will find 1 and 4 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion, continue the defendant on probation with probation's recommendations, which are that the defendant attend DDRF inpatient treatment with monthly UAs upon release. And the state is going to take into consideration County Court cause number CC 720-868. That's in County Court 9. And also that the defendant had no contact with the Pizza Hut at 1820 South General McCullough Drive.
All right, is that the agreement?
Yes, it is, Your Honor.
All right. Probation, is this your recommendation?
Yes, Your Honor. His top was recently done while in custody. It's the top recommendation.
All right, court will deny the motion, extend for 2 years. Transfer to DDRF. Take in consideration County Court cause number 720-868. There should be no contact with Pizza Hut. So if you want pizza, you'll have to make it yourself or either do Domino's or somewhere else, okay? All right, probation, is there anything else? Is there anything else you need from the court to be successful? All right, good luck to you. Who's the attorney for Mary Shepard?
I am, Judge.
Okay. All right, court is calling 2022 CR 5306, State of Texas versus Mary Luella Shepard. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Matters for the defendant.
And are you Ms. Shepard?
Yes, I am.
Going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Mary Luella Shepard who was placed on deferred adjudication in 2022 CR 5306 for the offense of unauthorized use of a vehicle on August 30th, 2022 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Mary Luella Shepard, did then and there fail to report to the supervision officer as directed for the months of September, October, November, and December 2022 in violation of condition number 4.
How do you plead to that? True or not true?
Not true.
State.
Violated condition number 1 on or about the 14th day of October 2022.
I'm sorry, I don't have a supplemental.
Sorry, it's in the supplemental.
All right, did you review the document entitled supplemental motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, I do.
All right, you may proceed.
Violated condition number 1 on or about the 14th day of October 2022 in Bexar County, Texas. The defendant, Mary Luella Shepard, committed the offense of theft, $100 to less than $750 in violation of condition number 1.
How do you plead to that? True or not true?
And Your Honor, we waive the other violations alleged in the motions.
Any objection? All right. Did you understand by pleading true to violation of conditions 4 and 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, I do.
Knowing that, do you still wish to plead true to violations 4 and 1?
Yes, I will.
Court will find 4 and 1 true. Is there a proposed agreement?
There is, Your Honor, we're asking that you deny the motion to be defendant on probation and extend probation for 1 year. We're asking that she can sign her conditions of probation in court today and follow the recommendations of the TAP evaluation, which are to provide proof of completion of the Haven for Hope's integrated treatment program and the outpatient treatment program with BCC SCD with monthly urinalysis and documented sober support meetings. And also the state is going to TIC County Court number 11, cause number CC 711696.
All right. Is this, you're asking the court to follow this?
Yes, Your Honor.
Probation?
Sorry, Judge.
Yes.
Also, no contact with HEB at 4100 South New Braunfels.
Probation?
Yes, Your Honor. Ms. Shepard did not show for her initial intake for her original term of probation. So we would ask that we extend for the 1 year to take account of that and then follow all of the TAP recommendations.
All right. Does your client have any mental health issues?
I don't believe so, Judge.
So why should I not just revoke her? She didn't show up. She didn't do anything. She disappeared and all she did was pick up a new offense. So why shouldn't she be revoked? She can find her way to the HEB. I know she could have found her way to probation. So why should I give her another chance? She hasn't done anything except picked up a new case.
I believe she will follow the recommendations of probation at this point, Your Honor.
All right. The court is going to grant the motion, find you guilty. Does anyone want to speak to a sentence?
Judge, we had talked about if she wasn't going to do treatment, something on the shorter end, Judge. So I'd leave it up to the court's discretion, but if she wasn't going to seek treatment, we talked about something on the lower end of the scale, Judge.
I'll sentence her under 1244. And I'll sentence her to 200 days at the Bexar County Jail. Is there anything else? And the court will take in consideration 711696 and give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendants' rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. You have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right. We can go off the record. Ms. Shepard, I want to let you know, I did listen to the recommendations from the state and the agreement that was made,
Yes, ma'am.
but you haven't done anything. You didn't report. You didn't do anything.
I understand.
All right. Okay. Good luck to you. Okay.
Thank you.
You're welcome. Prudencio Rodriguez. Motions to revoke or no?
Judge, there was confusion on that, but I confirmed with probation that there is no MTR.
Okay.
He terminated on that case back in November of 2021.
Okay. So I don't know why I have this, but all right.
They presented him with the MTR today, but we confirmed that there is no MTR.
All right. So where are we on these other cases?
So, Judge, I've conferred with both family violence. Mr. Bunk is on the ag assault family violence case and the UCW or the felon in possession. Ron
Mhm.
Ross is hired on the intox assault. So essentially we just need to get an offer from CTD for that case.
For the intoxication assault?
Yes, ma'am.
All right. Do you all know if you've tendered all of the discovery on that?
As far as I'm aware, there's extensive discovery on that. But since it's Mr. Ross that's hired on that, he hasn't been here, so I have to speak with him.
All right. So Ms. Ferguson, we're going to recall this for Mr. Ross to be here. And let's place it at the end of January.
The 30th.
Okay. All right. We'll see you on January 30th. Could you mute us for a second, please? Isai Santos.
Isai.
Isai. Oh, they didn't. Ah, Isai. All right. Are you all ready to proceed?
Ready.
All right. Court is calling 2023 CR 3928 State of Texas versus Isai Santos. Could I have parties announced for the record for the state?
State Your
John Robertson for Mr. De Los Santos.
And are you Mr. De Los Santos?
Yes, I am, Your Honor.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. De Los Santos, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it? Did you sign it?
I did, Your Honor.
Counsel, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
I did, Your Honor.
Did you understand you're charged with the offense of possession of controlled substance, penalty group 1, 4 grams to 200 grams? That is a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am. I do.
Did you understand by entering this plea, you were giving up those rights?
Yes, I do.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
I do.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Believe so.
Mr. De Los Santos, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you see the plea bargain page with your attorney? Did you review it and did you understand it?
Yes, I did.
According to the plea, punishment is to be assessed at a cap of 4 years and the state is silent on your application. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions? Then to the offense, I'm sorry, I keep looking at you. Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
Your Honor, I offer State's Exhibit 1 and the attachments.
No objection.
Showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We'll come back on February 8th. At that time, I'll make a decision on your application. It will be based upon any evidence that's presented to the court. Do you understand?
Yes.
All right, gonna order PSI and TAP.
He's been in custody since November 6th. Would the court consider releasing him on PR bond pending sentencing?
No. All right, and off the record, I see they took care of that. Did they? Was that a fight at the jail?
Yeah, I was an assault. But yeah.
Oh, do you need to be placed in protective custody?
No, not right.
Okay, all right,
Thank you, Your Honor.
thank you. Virginia Cerner. Hello, Mr. DeLeon.
Good morning, Your Honor.
Good morning.
Good afternoon.
This is our last case until this, we're gonna take a break after this. Oh, I'm sorry, you're on this side.
Sorry.
We have new rules. All right,
2024 rules.
yes, so what is happening with this case?
Judge, we set this for a bond reduction hearing.
Mhm.
Ms. Cerner was on in approximately April 2023, ag assault. She was on a $15,000 bond. That bond was revoked after a violation report because she was charged with 3 aggravated robberies in late October.
Mhm.
For the past 45 days, I've got no information regarding the ag robberies whatsoever beyond 3 sentences and a probable cause affidavit. But this morning, Mr. Wilkins provided me with a nice prosecution guide. And apparently there are some videos that are now uploaded that finally the San Antonio Police Department has provided. So what I want to do this morning is just be able to review this, come back next week.
Okay.
And then we can do the bond reduction.
All right, what time next week would you like to come? And I know you all were here last time and it was agreed that witnesses, if there were witnesses that were needed, they could appear by Zoom. Is that still the case?
It is still the case, Your Honor.
All right, when do you want
Sorry.
brought back? And Dinah, we're on break.
How's your Tuesday or Thursday next week, Judge?
Ms. Ferguson, how's Tuesday or Thursday next week? All right, Tuesday?
We'll do Tuesday.
All right, I will see you back here on Tuesday. They have a hearing on a
Motion for
bond.
reduction.
So see you back on the 9th.
Thank you, Judge.
Thank you. And you entered a plea of no contest. While it's not written on the docket sheet, the court did review what the previous judge who took the plea read. And I know that that judge found there was sufficient evidence to find you guilty, but the court deferred finding of guilt. I read the police report and the stipulations, but I'm basing my decision just on the police reports. I'm also finding that there is sufficient evidence to find you guilty. However, I'm deferring finding of guilt because you've applied for deferred adjudication. According to the plea, punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine, and the state is opposed to your application. There's to be Chapter 62 compliance and no contact with the complainants. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state?
None from the state.
Defense?
No, Your Honor.
All right. Any witnesses, state you're opposed?
No witnesses from the state judge, just from you.
All right. Defense, any witnesses?
No, Your Honor.
All right, then the court will hear argument. State, you're opposed?
We are opposed, Your Honor. We would ask that you hit the cap of 10 years and send the defendant to prison. He perpetrated numerous sexual assaults on the victims in this case. Alyssa is the oldest victim and the victim that the state has had contact with pretty much this whole time, Judge. I did speak with her in person and just want to let the court know that she was extremely emotional when describing the acts that her stepfather perpetrated upon her. It was very difficult for her to talk about. She had to take several breaks and it was very emotional for her. You can see the impact that it has upon her in her everyday life. The youngest victim, Ariana, the state has not had the opportunity to speak with in person. The mother of Ariana has not allowed us to speak with her. However, Judge, I believe last week she did finally turn 18 years old. It was unfortunately not in time for the PSI officer to reach out to her and to get her opinion on what should happen in the case. However, in speaking with Alyssa, I want to comment on the no contact order. Alyssa does not wish to have contact with the defendant. I don't have that coming from Ariana, Judge, but again, Alyssa is very emotional about the whole thing. She doesn't want to do anything that will get anybody in any more trouble than we already have here today. So these acts with regard to Alyssa were perpetrated on her numerous times over the course of years, each time that her mother went to work and the defendant was granted access to her, and they were escalating in nature. It began with touching and escalated to full-on penetration of the complainant's sexual organ by the defendant's penis on numerous occasions. We did plead to a lesser included, Judge, but those are the facts of the case. With Ariana, we do have indecency with a child by contact, where the defendant made her touch his erect penis on more than one occasion, Your Honor. We would ask that you send the defendant to prison for the full 10 years.
All right, defense.
Excuse me. On behalf of my client, Judge, he doesn't have a significant criminal past history. My client feels that he would be a good candidate for probation if, notwithstanding what rules that court can place upon him, he feels that he would abide by those rules. He would govern himself. If there's a violation, then at that point, the court would have a full range of punishment if the court wants to send him to prison. He just feels, Judge, that if he's given that opportunity, that chance, he would take whatever courses he need to take, anything that has to educate himself with regards to the nature of these cases. He's more than willing and able to do, and we just asked Judge that the court consider deferred in this case, and that's our position, Judge.
All right. Mr. Lynn, is there anything you wish to say?
I know.
Any questions for Mr. Lynn?
No, I don't have any questions.
Okay. All right. What I can tell you is I don't have a trial court certification. It was one that was done by Judge Angelini that was signed, but I need one for today. A trial court certification of defendant's rights to appeal.
You want it post sentencing or?
Well, if you all can grab it now, and then I'll make my decision. And I do have a question that maybe counsel can answer for me. In the stipulation, it says, and this is the narrative, so I'm assuming it's coming from your client. It says that he is married common law for 18 years and has a 15-year-old son.
Yes.
So is that person that he's common law married to the same person that's in this?
This person that he's common law married to, forgive me, Your Honor, I don't recall her name, but that is Ariana's mother.
Okay. And are they still together?
Yes, Judge.
So I'm assuming that is why, well, I don't like to make assumptions. So is that the reason, my question is that the reason why there is trouble having the other complainant come in?
I believe so, Your Honor.
And when it depends on how you define trouble. So sometimes trouble could be also a good trouble. You know,
Yes,
I've heard that phrase.
I've heard that phrase too, Mr. Cox.
So, she was supposed to come here today, but I think that she may have had some reservations about how everything kind of came to fruition. And I believe that she has, there's still a relationship between her and my client.
Well, if you would like her to zoom in, she's more than welcome to zoom in. If you want to.
Yes. I have a moment to.
Sure.
What we do,
It's up to you. You do your best.
let's see if
I mean, if you want her to zoom in, I'm sure she'll be subjected to questioning. How rigorous the questioning is, I guess, depends.
do we know whether the questioning will come from prosecution or the court? That's basically.
State, will you have questions?
Oh, I have a lot of questions, Judge.
They will come from the prosecution. If no one wants me to ask questions of her, of course, I will not ask questions of her because she's a witness. The only person who's remained their right to remain silent has been your client. So if you all would like her to appear by Zoom, State, will you have any objections to her appearing by Zoom?
No, Judge.
All right, we can have her appear by Zoom.
For again.
Of course.
No, question? Yes. 728.
And we're off the record. Ms. Abrams, on Mr. De Hoyos, we had talked about that case.
Yes, sir.
I received an email from Felony Drug Court. They're willing to speak with him if he wants to go back to Felony Drug Court.
Yes, I'll be here in the morning.
Okay. All right, and I'll forward their response because his caseworker, former case manager is willing to meet with him. All right,
Let me see if I can call her.
okay, sure, just have a seat. All right, court is calling 2022 CR 11858, State of Texas versus Victor Garcia. Can I have parties announced for the record for the state? For the defense?
Miguel Hernandez for the defense.
And are you Mr. Garcia?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Garcia, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions
Yes,
with
Your Honor.
your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand by indictment, you're charged with the offense of murder? The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 35 years in the prison, and there are no applications. Of course, you're not eligible for deferred adjudication for murder. Did you understand?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
It is.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence to support the defendant's guilty plea.
State offers State's Exhibit 1 with all attachments.
We've had a chance to review, Your Honor, no objections.
Mr. Garcia, did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We do.
All right, anything you wish to say on behalf of your client?
Your Honor, we would ask that the court go along with the plea bargain offer. We believe that it should satisfy the actions of my client. He's taking full responsibility, Your Honor. The only thing we would ask, other than for you to follow, is that there was a mental situation. He has been psyched, he has been competent, found competent, but he is on medication. So we would ask that for his sentencing, if he be put in the medical units, the court could recommend that for him, because I believe that he does have mental issues, but the medication is taking care of it. And it was determined at the time of the incident, he did know he did history mind well.
All right, State?
The family is present in the courtroom. They do not wish to get it.
All right, and so they're aware of this sentence and in agreement with it? All right, the court is finding you guilty. The court will sentence you to 35 years in the prison. There's credit for any time served. And I'll request the mental health unit. However, it's completely up to the prison, but I'll request the mental health and
Thank you, Judge.
therapeutic unit.
Thank you, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So I understand that sometimes people do things and then later they regret it. I read the stipulations and I've seen the stipulations that there's issues of maybe drug-induced psychosis and also mental health issues on top of that. You're going to have to change your ways. You're going to have to get a handle on your mental health issues and also your drug issues. Do you understand?
Yes, ma'am.
Because somebody is no longer here because of your actions. All right, good luck to you.
Thank you, Your Honor.
You're welcome. Aiden Martinez. Is the attorney here for Aiden Martinez?
You just caught me, I was getting ready to walk.
All
Then I probably wouldn't have come back until like 11:59.
Yeah, then you would have been rushing and I would have said, I'm not here. I'm on lunch break. You see me, but I'm not here. All right, where are we on DPS labs?
So Judge, I think Hank was supposed to turn it in. We reached out to see if Hank had ever reached out to DPS to get it. If not, we'll do it immediately.
All right, Ms. Ferguson, on this case, recall this for 30 days. And this will be the last day for labs.
Thank you, Judge.
Yes.
Thank you, Judge. Appreciate it.
Oh, well, you need to- Who's here? Willie Cunningham.
Judge.
All right. Hello, today is plea deadline date.
Yes, Judge, and we do not have an agreement, so
All right, State, how long do you expect this trial to last?
I don't think it would last longer than
3 days.
3 days. Yeah.
All right, Ms. Ferguson, on Cunningham, I need a reset date for trial, family violence, 3 days. And I don't have a copy in my file of acknowledgement of discovery. Did you all complete one?
I don't think we did. So I was looking through because I see my red pads put at an abundance of caution. I'm just gonna redo one today if that's okay, Your Honor.
Yes, thank you.
That's all good. Sure.
All right, we'll come back on August 12th and you'll be in impact court. So you'll report on the second floor. All right. All right, once you sign the reset form, you're excused. Thank you for always dressing appropriately for court. Who's here on Mark Johnson? I'm sorry, Joshua Mackay.
Right here.
It was on I went to the Arrowson. Jaylen Zavala.
Ah, I see it. All right, so what are we here for on this case?
Judge, we're set for initial setting on an MPR. I've conferred with the state. We're requesting a 3-week reset to resolve one of the violations. And then I believe we will have an agreement on the MTR. But the state wishes for us to provide some type of proof that this new number one is going to be dismissed out of Harris County. So we're just requesting a short continuance to get that accomplished.
All right, Ms. Ferguson. Reset this for a contested in 2 weeks. That's the last setting you all will have.
Judge, you when you set his bond, you put a condition of GPS. We're asking the court to possibly reconsider putting that on. He has until the 24th to have the GPS put on. This is his first MTR after 9 years, and he has shown up to court every time. We're asking the court to reconsider placing that GPS condition on.
No. All right, Ms. Ferguson, what date?
July 9th. The 2 weeks falls on the holiday.
All right, we'll be back on July 9th. That will be a contested hearing. All right.
Absolutely.
Thank you,
Yes, thank you.
All right, thank you. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court. All right, who's here on Joshua Mackey? All right, so today is contested.
Yes, Judge, we've withdrawn.
All right, so I know that y'all have withdrawn, but there are issues in the motion to revoke. Have those been addressed with the withdrawing of this?
Yes.
Yes, Judge.
All right, thank you.
Judge, he has GPS on his ankle. Does he just go over to pretrial right now, or?
Sorry, what?
He has GPS on his ankle. Does he go to?
All right.
pretrial or no?
Is there a reason he's on GPS?
You put him on GPS, Judge.
The bond.
Conditional bond.
Okay. All right, State, are you going to have any objections to the removal of GPS?
No, Your Honor.
All right. All right. We're going to go on the record. Court is calling 2014 CR 5495, State of Texas versus Joshua Mackey. Can I have parties announced for the record for the state?
Allie Jackson.
Defense?
Kelly Piddle.
Are you Mr. Mackey?
Yes, ma'am.
All right, everyone, we're on the record. No talking in the box. Just a moment. All right, why were you late for court?
I wasn't late.
Yeah, you were late.
Okay.
If you're not in the courtroom at 9 o'clock, you're late.
He's in the hall, Judge. Mistaken.
Well, I mean, he can talk. Why were you late?
I was in the hall
Why were you not inside the courtroom?
because I was waiting for my attorney.
All right, court is inside the courtroom. It's not in the hallway.
I understand.
All right, so with regards to the motion to withdraw,
Yes, Your Honor, the state is, has signed a motion to withdraw the motion to revoke, Your Honor.
all right, and so you're saying that the issues within the motion have been addressed?
Yes, Your Honor, out in Harris County, yes, Your Honor.
All right, now with regards to the GPS removal, do you have any objections?
No, Your Honor.
All right, then GPS will be removed. And probation, you have no objections to the removal of GPS?
No, Judge.
All right, make sure you stay in contact with probation. Probation will tell you what you need to do.
Thank you, Judge.
All right, thank you. Who is here on Richard Rodriguez?
Present, Judge.
Okay. And probation, this is an application. Court is calling 2024 CR 5668, State of Texas versus Richard Rodriguez. Can I have parties announced for the record for the state?
Is that done for the state, Your Honor?
Defense.
Renee Munoz on behalf of Mr. Rodriguez.
And are you Mr. Rodriguez?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, that's correct, Judge.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the document entitled Court's Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault family second offense? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that did you understand that by entering this plea today, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as the factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, the state is recommending deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, sir.
Did you understand that to be your plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation and no harmful or injurious contact with Angela Cervantes. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State offer states 1 and attachments.
No objection, Your Honor.
And state, have you spoken with the complainant?
We have been able to get a hold of the complainant, Your Honor, and they have made it clear their lack of interest in supporting the district attorney's office.
All right. You may be excused. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
If we may, Your Honor.
All right, the previous assault case he has, who was that alleged, well, not alleged, who was that against?
Angelo Cervantes?
The previous one.
Oh, Amber Rose Jimenez.
All right, Amber Rose Jimenez, and now it's Angela Cervantes.
Yes, ma'am.
What is your issue?
I don't have an issue.
Well, I mean, you're here for your second assault, so obviously there's an issue. It appears that she wanted you to leave her residence and she was breaking up with you. Was that your residence?
I was living there at the time.
Was your name, was it an apartment?
No, it was a house.
Was your name on the lease of that home? Yeah, so she didn't want you there anymore.
Right.
So you don't have anywhere else you can go?
Well, no, not at the time I didn't.
Do you have any family members?
Yes, ma'am.
Mom, dad?
Yes, ma'am.
Are they in Bear County?
Yes, ma'am.
So why can you go to them?
Oh, I can now.
No, I mean, why can you go? I would like to think, and if I'm wrong, tell me I'm wrong. If somebody were to kick you out of their home today, there is a family member where you can knock on the door and say, hey, I just got kicked out. Can I stay here?
Right.
As opposed to, according to this, they found you in a drainage ditch. So what don't you understand when people don't want to be with you?
Sean, I think he's had a lot of time to mull that over. He's been in custody the last 4 months, and I asked him specifically about this instance, leading up to his arrest. He said that it was out of character for him. He just found out it was a toxic relationship with this individual. He stated he's not going to even consider getting back with that individual, that bridge has been burned, and he's looking more so to work on himself. And
So why is outside the agreement no harmful or injurious contact with Angela Cervantes?
I think it's because Judge, she didn't really want to testify. I don't think there would be any issue if it was a change to a no contact order. She didn't really want to proceed because she stated to me, and I believe the district attorney's office, that I was out of his character as long as she has known him, and she doesn't want him to be confined more than he's already been confined for the last 4 months, Judge.
All right, so it may be her experience that it's out of character for him, but he has a previous assault case. You can't go around hitting on people. Guess what? When a relationship is over, you need to leave. And if you are in a relationship with somebody, and either if it's the female or the male or whoever's in the relationship, if you get to the point that you want to put your hands on somebody in violence, don't do it. You leave. That's when you know the relationship is over. If you think someone is cheating on you, you have a choice. Either I think this person is cheating on me, but guess what? I'm going to accept it and stay with them. Or either I'm not going to accept it. I'm going to leave. It never should get to the point of violence. Do you understand?
Yes, sir.
And what is the tattoo on your neck for?
Oh, this is my daughter's name. So,
All right. That's good. I always tell people, if you're going to put a name on your body, it should be either your mom, because they're supposed to love you, or either a child, because you're always supposed to love them. When's the last time you were employed?
Let's see, about 6 months ago or so. I never had a problem having a job. Always had a job.
How many children do you have?
3.
What are their ages?
Got an 11-year-old boy, 10-year-old girl, and a 9-year-old boy.
All right. So do you have the 11-year-old and the 9-year-old's name on your body? That's either yes or no.
No.
All right. So do they feel like maybe you don't love them as much because you have Sophia tattooed all across your neck? Where's the 9-year-old and 11-year-old's name?
Right. Well,
I mean, these are just questions.
I know. I just
down the pipeline, Judge.
I don't know how that's relevant, but
Because I'm asking it.
Okay.
And I want my questions answered.
Maybe soon get it.
No, I mean, you don't have to. I'm just wondering,
Okay.
do your children feel some sort of way if you only tattoo one child's name on your body?
She may be the princess, Judge, because it's
Yeah,
a girl,
she-
so that's why he has to cater to her.
Well, he should put Princess Sophia.
That may be coming too. I don't know. Hopefully not. Want to hopefully stray away from any more ink at this point. Richard.
Any drug use?
No, ma'am. I've been clean for a year.
All right. And what was your previous drug?
It was methamphetamine. I was on it for 12 years and I've been recovered addict for a full year. That's probably
And how far did you go in school?
graduated high school.
And what type of employment have you had?
I've been a cook for the past 13 years.
Where?
Denny's
probably every dentist in San Antonio, Metropolitan Methodist Hospital, Northeast Methodist Hospital, Cracker Barrel, IHOP.
Breakfast places or diners, kind of things like that.
Breakfast places.
And if you release, who would you be living with?
My mother.
All right. Have you asked her if you can live with her?
Yes, we have gone over just briefing about it, but I'm sure I will be able to.
Well, no, people always assume they can live with their parents, but did you talk to her and say, Mom, when I get released, may I live with you?
Yes and no.
What does that mean?
Kind of put it out there, but
And she hasn't picked it up. So you threw it out there and she hasn't picked it
I'm
up.
sure she will say yes. Sure she will.
So we don't know where he's going to be living. So this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's to be no contact with Angela Cervantes. There's to be regular reporting by Zoom or in person. There's going to be 100 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, the community service hours will be deemed satisfied. And the children that you have is Angela Cervantes the mother of any of them?
No, ma'am.
There is to be an affirmative finding of family violence, the BIPP course. And I'm going to order that he stay at lifetime recovery.
Well, there's actually a ministry that I was staying with before. The San Antonio Christian Church Discipleship School and Ministry off Days of Honor Road.
Mhm.
And from there, kind of got taken out, moved in quick with Angela. Lived with her for about 3 months, and it was a vicious cycle of her kicking me out
All right.
and calling me back.
Oh, well, we're going to help you out right here. So I'm giving you your orders. You're going in lifetime recovery. There's going to be a TAP evaluation. What's the length of time of TAP in custody? All right, so that'll be a TAP evaluation while in custody as well. Follow TAP recommendations, 120 sober meetings in 120 days. Proof of employment within 30 days. No employment as a home health care provider with minors. No unsupervised contact with minors. And field visits one time for 4 months. There's to be regular random UAs. And then regular reporting. I already said regular reporting by Zoom or in person. Probation, is there anything else he needs? He's going to be staying at lifetime recovery. And you're going to be at lifetime recovery until I allow you to leave lifetime recovery. So there will be none of this. I just met a new girl, so I'm leaving lifetime recovery. Do you understand?
Yes, sir.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right. Is there anything else you need from the court to be successful?
No.
All right. We can go off the record. So let me just tell you something. Do I want to be in anybody's business? No. I would love if we lived in a world where everybody could be in their own business instead of being in other people's business. I ask questions because guess what? The only thing I know about you is that you've assaulted a person twice, somebody that you've been in a relationship that you supposedly love. That's all I know about you. So I ask these questions so I can learn more about you. For example, the name Sophia. Who is that? Is that some other female that you've gotten so deep in that you want to put her name on your neck? Do you understand?
Yes, sir.
All right. Good luck to you.
Thank you, Judge. Maybe excused.
Yes. John Martinez.
Good morning, Your Honor.
Good morning. I see that. I know that he's set for the 27th, but we're here on these motions.
Yes, Your Honor.
All right. Is his girlfriend here?
Yes, Your Honor.
All right. Court is calling 2024 CR 4455, State of Texas versus John Anthony Martinez. Could I have parties announced for the record for the state
Zach Dunn for the state, Your Honor.
defense?
Leah Alon here with Gary Barton's office representing Mr. Martinez.
And are you Mr. Martinez?
Yes, ma'am.
All right, there's a motion here to amend bond conditions. I believe that is the aggravated assault with a deadly weapon is the complaining witness, the defendant's girlfriend?
Yes, Your Honor.
All right, and I believe that she wants the no contact order lifted?
That's the state's understanding, yes.
All right, state, are you in agreement with lifting the no contact order?
We let council know that they had two separate motions, one for the GPS, one for the no harmful. We were in agreement to well, depending on the former or latter with respect to partial to monitoring, Your Honor.
Okay.
But we almost essentially, we're happy to, if the court would like our recommendation, we almost stayed silent, given we were hoping to hear from the complainant, given their presence in the courtroom today.
All
With
right,
respect-
so with regards to GPS, then the court will allow for tracking. Now, anyone want to call the complainant?
Yes, Your Honor.
All right, so before you all call her, is this an issue where the complainant is going to come and say this didn't happen?
If my understanding is correct, it's not so much a reneging or taking back that something happened, so much as it's a putting forth a complainant's intent to not assist in prosecution is the state's understanding.
All right, because if she is, let's call her up. What is her name?
Her name is Shania Hernandez, Your Honor.
Shania Hernandez, come forward.
I believe she is outside of the courtroom.
Yes.
May I go get her?
Yes.
Martinez. Stand right here, put your back.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Shania Hernandez.
All right, Mr. Hernandez, if you are coming in to say that this did not happen, then you will need an attorney to represent you. I'm not saying that the state would file charges against you, but it is a crime to file a false police report. Do you understand?
Yes, sir.
All right, so are you coming forward to say that this did not happen? All right. Anybody wish to ask her questions?
Yes, Your Honor. If I may, could you please spell your name for the record
Shania.
and your last name?
Herndez.
And can you describe the nature of your relationship with Mr. Martinez before the incident?
We were in a long-term relationship with a child.
I'm sorry, I cannot hear you.
Sorry, we were in a long-term relationship with a kid.
And how many children do you share together?
One, boy,
And how old is your child?
2 years old.
And since the incident, have you had any contact with Mr. Martinez?
No, ma'am.
Have there been any violations of this no contact order?
No, ma'am.
And do you have any safety concerns specifically as they relate to Mr. Martinez?
No, ma'am.
And has it been challenging to avoid contact with Mr. Martinez for yourself and your son?
For my son, it's just kind of hard doing all this for myself and not having, the parent that agreed to become there.
What sort of difficulties have you experienced?
Like on weekends, I always have to find somebody to watch him because his daycare doesn't carry through on weekends. So it's always me trying to either get a family member to help or, sometimes it's hard being able to get diapers and everything, what he needs throughout. And I don't really have anybody to ask for help.
And do you have any concerns or reservations about modifying the bond conditions in this case?
No.
I'll pass the witness, Your Honor.
No questions, Your Honor.
All right, I have a few, if there are no objections.
No objections from the state.
How old are you?
I'm 22 years old.
And how long have you been in a relationship with him?
3 years.
All right, and how does your family feel about your relationship?
Mm,
Are they opposed to it? Were they always opposed to it, or they just now are opposed to it?
They're just not opposed to it.
All right. All right, thank you.
Thank you.
Oh, you can come back. Any other evidence?
Nothing from the state, Your Honor.
All right, so this is what the court is going to do. One, I'm not allowing him to have face-to-face contact with her. According to the indictment, and I don't take any of it as true. I'm just here on an aggravated assault with a deadly weapon, but it's alleged you pointed a firearm at her. So I will allow him, because she's saying she needs diapers, she needs this. He can call, I think they do, what is it, DoorDash or whatever they do. I know you can order at the grocery store and they will deliver it. So you can, if you want to help take care of your child, guess what? You can go online. I will not consider it a violation if you're ordering Pampers or whatever food items you want to have delivered to that home, but you are not allowed to deliver it. Do you understand? You're not allowed to have contact. If there is some sort of agreement regarding the child, I have no jurisdiction over the child. If somebody has legal documents where he can have visitation with the child, that needs to be done through a third party, not through her. So the only contact you are allowed to have with her is having groceries delivered.
Could I have my mom deliver anything to her?
Yes, your mother can deliver items to her as well. You are not allowed to have face-to-face contact with her. State, do you have any objections to him maybe having, I don't know, I guess Zoom time with his child?
No objections, Your Honor, and I think providing him any civil documentation would also help the state in the future with respect to the child, so
Okay.
absolutely, Judge.
All right, so there's to be no in-person contact with the complainant. So that means that you can have contact by Zoom. You all want to talk and you want to see the baby through Zoom, you can. But you are not allowed to go to her place of employment if she's employed. You're not allowed to go to her residence. If there's a family barbecue and she's there with her family, even if the baby's there, you're not allowed to come over. You understand? Is there anything that you do not understand about the court's instructions? All right, so there's to be no in-person contact with the complainant, and GPS is tracking only, and the court is asking that fees be waived. All right, is there anything else?
Nothing from the.
All right. All right, Albo Tucker,
Present, Your Honor.
what is happening with this case?
Your Honor, I was disappointed to Mr. Tucker's case. We found a resolution. I'd like to bring him back probably on Tuesday. There are some misdemeanor charges as well that he needs to plead to, and we need to make sure that he pleads in the misdemeanor court as well on that day. I want to coordinate that. If we can come back on Tuesday, that'd be wonderful.
All right, Ms. Ferguson, on Tucker, if we can recall this on Tuesday, and that would be the 25th. All right, is there anything else?
That's it, Judge.
All right, thank you. Armando Garcia,
Present, Your Honor.
are you ready to proceed?
No, Your Honor. Apparently there are new number one cases that just happened about 3 weeks ago, aggravated assault of a public servant. I've been appointed onto those. I haven't gotten any discovery on them. So what we'd like to get a reset so I can research that, and we'll go from that point.
And Judge, on that one, I looked into it. All we have on our end so far is just PDFs, just the reports. I don't even think an intake attorney's been assigned to it yet.
All right, Ms. Ferguson, on this, can you recall it in 45 days? We're going to bring you back in 45 days. If your attorney wants you brought back sooner, he'll let us know.
Yeah.
And it is Armando Garcia. All right, we'll bring you back on August 5th. And Norma, set that as a discovery. Thank you.
I'll be back in touch with you before then, okay? All right, thanks, sir.
Who's here on Jaylen Zavala? Good morning. All right, so on this one, there's an issue with payment, correct?
Yes, Your Honor.
All right, is she able to pay?
No, Your Honor. So
I was appointed to represent Miss Zavala in January of this year. She was arrested for the state jail felony offensive driving while intoxicated with a child passenger. The court did permit her to have an in-home device. However, Miss Zavala lost her job and has been unable to secure employment. As such, she fell behind on the calibration scheduling for that in-home device.
All right, where has she looked for employment?
So, Judge, from May 29th through June 10th, she's applied at multiple different.
What places?
She was working at Amazon in January, and then she's now applied to Walmart, to a staffing agency called Balances Staffing.
All right, they're hiring at Chick-fil-A, they're hiring at McDonald's, they're hiring at Burger King, they're hiring at Whataburger.
And she's applied to Dairy Queen, Auntie Anne's, as an optical sales associate somewhere else, Snowbird, Shaved Ice. So she's made.
Okay, I think you should apply, try McDonald's, Walmart, Whataburger. Is he talking to someone?
No, I'm not sure.
Who is speaking to the inmate? Who are you speaking to? I'm sorry, who? Where is he? Yes, you're excused.
I was trying to get him this letter. Give his lawyer and trying to figure out.
Give it to the deputy and then you're excused. All right, thank you.
So Judge, she has been making those applications. I was going to see if the court would consider possibly waiving that in-home device. Miss Zavala, while she was arrested for that DWI with child, there is an exception under 17.44B. It says a magistrate can waive an alcohol monitoring device if it's not in the best interest of justice. I guess for the court to make that decision, the court would need to know that when she was arrested for DWI, she was incredibly cooperative and compliant. She did provide a breast specimen and it came back at a 0.01 and a 0.02 respectively. So it's not alcohol that was the issue. I don't know whether drugs are on board or not. However, it is my understanding that the state has submitted the blood, which she did consent to provide a specimen of to DPS for a toxicology exam.
State, do you want to waive the in-home device or no?
17.441B, Your Honor, and it is at the discretion of the magistrate if you find that it is not in the interest of justice.
Well, I know, but are you in agreement with the waiver of it?
Yes, Your Honor.
All right. Then what are we going to do instead of that?
Well, Your Honor, she's not driving. She doesn't have a vehicle. I don't know whether there are drugs on board. The report doesn't seem to indicate that there is any sort of presence of drugs. I would say possibly maybe if you would want her to submit to a weekly UA. Transportation has been an issue because she's not driving and she's been relying on her father to get her to different appointments, and he does have a full-time job.
All right, this is what the court is going to do. The court is going to waive the condition of the in-home breathalyzer. I'm going to order no driving. So you're not allowed to drive. Do you understand?
Yes, ma'am.
And I'm going to order sober support meetings. And you can do those by Zoom. And I'm going to order 60 sober support meetings in 60 days. And there's going to be regular UAs. And I'll waive the fee. And I'm going to have them test for alcohol. And those UAs need to be once per week.
Yes, Judge.
All right, is there anything else? All right, thank you.
Thank you.
Thank you. You're welcome. Manuel Sandoval. Are you all ready to proceed?
All right.
Court is calling 2023 CR 3142, State of Texas versus Manuel Sandoval. Can I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
Matthew French for Mr. Sandoval, ready.
And are you Manuel Sandoval?
Oh, yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Manuel Sandoval who was placed on community supervision in 2023 CR 3142 for the offense of assault family, second offense on August 29, 2023 for a term of 6 years. Is that you?
Yes, Your Honor.
State?
Your Honor, on or about the 9th day of January, two thousand and twenty-four, in Bear County, Texas, the defendant, Manuel Sandoval, did then and there fail to attend and complete Bear County CSCD's Substance Abuse Intensive Outpatient Treatment Program in violation of condition number 30.
How do you plead to that? True or not true?
True, Your Honor.
And the state will waive and abandon the other violations, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 30, the court could find it true, grant the motion, sentence you up to 6 years in the prison and up to a $1,500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 30?
Yes, Your Honor.
All right. Court will find 30 true. Is there a proposed agreement?
There is a proposal, Your Honor, yes.
Yes.
I think state had let it be known to council, the drug use was a primary concern. Following the recommendation for amending of conditions to include SATF followed by aftercare. And I know council wants to speak on some more things, but that is the proposed recommendation.
All right. So I'm not going to follow that agreement. This is not his first motion to revoke, and I had already previously put those conditions in place, and there has been no follow through.
Well, he's not been into an inpatient treatment program, Judge. He's agreed to do that today. Judge, just a little bit of background. He was having difficulty. It's referenced in the reports to the court. He was having trouble with finances, keeping jobs. He was doing odd jobs. He's also in this time period, Judge, his father was diagnosed with prostate cancer and has been given only about 6 more months to live, which is the time is ticking on that as well. So he has some other issues that he was dealing with. He understands the situation. He's asking the court to follow that agreement. I understand the court's concerns about it, but drugs seem to be the issue for him, and he's willing to go to that inpatient treatment, Judge. He still has quite a bit of time left on probation, so the court could continue to monitor him after that drug treatment.
All right. This is what the court is going to do. The court is going to grant the motion. There's an affirmative finding of family violence. The court will sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Santos, Sands, S-A-E-N-Z, Andrade. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
So did Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you are on community supervision. The court will request therapeutic community for you. Whether or not you're placed in that is not in my jurisdiction to order, but I know they will definitely not consider that for you if you do not request it. It does not increase the time that you're in custody. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge.
You're welcome.
Have a seat, sir.
Everybody know? Who's here on Annette Drago? Come forward, please.
Happy New Year, Judge.
Happy New Year. We made it.
We made it.
Oh, and counsel, I'm sorry, you're all on this side now.
Okay.
All right, this is for sentencing, correct?
It is, Your Honor. Yes, yes, sir.
All right, who's the prosecutor on Annette Drago? Is this criminal trial division?
Yes, Your Honor.
All right, Jason, are you on this? Yes. Okay. Everyone, we're going to go on the record. So counsel, if you can ask the deputies, they'll move you down there. You're welcome. And do not, as a reminder, do not approach the bench or the coordinator or the clerk when we're on the record. Court is calling 2023 CR 7274, State of Texas versus Annette Drago. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Good morning, Your Honor. Daniel Del Garza for the defendant.
And are you Annette Drago?
Yes, ma'am.
You entered a plea of guilty on November 16th. According to the plea bargain agreement, punishment is to be assessed at 9 years in the prison. There's an affirmative finding of deadly weapon, and the state is silent on your application for deferred adjudication. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor, we're reviewing it right now, but since you're silent, I'm fine with reviewing it and going on.
All right. Defense?
I have reviewed it, Your Honor, and showed the same to my client.
All right. Any objections to the PSI report? Defense?
No, Your Honor.
All right. All right. The state is silent. Defense, do you have any witnesses?
We don't have any witnesses, Your Honor. I would just like to point out that
Missy Drogo's husband is in the courtroom.
Okay.
Her father is also in the courtroom, he's standing. She has a supportive family, that kind of stuff.
Okay.
I don't think the testimony is necessary. I can argue it and it's in the PSI. But
Okay.
so we have no witnesses.
All right. Well, if you want to address with your client, because there's where it says guilt acknowledged, there's an X there, which I'm assuming guilt is acknowledged, but there is also an X that says guilt is minimized.
And I could ask you some questions, Judge.
Sure. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record, please.
Annette Garcia.
All right. Make sure you keep your voice up so that the court reporter can hear, all right? All right, defense.
Thank you, Your Honor. And you know you're here for sentencing today, right?
Yes.
And you pleaded guilty to aggravated assault with a deadly weapon.
Yes, sir.
Right? Now tell the judge at the time, and it's in the PSI, we talked about it, but tell the judge at the time that this was happening, what was going through your mind?
Self-defense, Your Honor. I was
And-
simply trying to defend myself. I'm sorry.
Okay, that's fine. And then now, since I've become your lawyer, you've looked at the evidence and all that kind of stuff.
Yes.
Have you realized now, do you know whether it was self-defense or not?
Yes,
And you think that it was not, or do you think it was self-defense?
I believe in my heart it was self-defense.
Now, do you take responsibility for what happened, though?
I do know now that it's, in my mind, in my heart, it's self-defense.
But you know now that it
But I
was,
know, yes, sir.
tell the judge that it was
I
what?
do know now.
All right, so I'm sorry, if
Yeah,
you all
that means-
can slow down and one at a time.
So tell the judge whether you think now this was self-defense or whether this was illegal.
I know now it is illegal, but at the time it was self-defense.
All right, so then the question is, do you take responsibility and do you acknowledge the guilt for the aggravated assault with a
Yes,
deadly
sir,
weapon
I do.
case? Hold on, aggravated assault with a deadly weapon case. Do you acknowledge your guilt?
Yes, sir.
And what are you asking the judge to do today?
If I would please get probation, this is my first offense. I simply was scared for my life, trying to defend myself.
And tell the court, why should the judge put you on probation?
Like I said, I know now if this would never happen again.
First off, right?
Right.
Do you have a criminal history?
No, sir, I don't.
Maybe a very limited one from Hidalgo County, like a harassment or something that's on the.
None of
All right, everyone one at a time. Okay, go for it.
Okay, and if you're granted probation, do you know that there's terms and conditions that come along with it?
Yes, sir, I do.
Are you going to follow all those terms and conditions?
I'm willing to comply all the way.
Are you going to use drugs while you're on probation?
No, sir, I don't use drugs.
You don't have a history of drug
No,
use, right?
sir.
Are you going to work?
Yes, sir.
And the
Working.
PSI says that you're a caregiver, right?
Yes, sir.
Are you able to go back to some kind of job like that?
Yes.
Now, what if the judge says you're not able to work as a home care provider or anything like that? Are you able to find other kind of employment?
Yes, whatever is suitable for me.
Where would you go live?
My parents at the time being.
And do they live in close proximity to Miss Hernandez, Miss Tracy Hernandez?
No.
If the court orders you to stay away from the complainant in the case, would you stay away from her or would you go back to the Goodwill? And
No, I have no business. Near her.
is there anything else that you'd like to tell the court before we stop?
Just that I'm truly deeply sorry, and I know now that all I was trying to do was defend myself. It was simply self-defense. I'm a mother of 5 kids, and I'd like to go back to see my kids. I didn't see them for Christmas, Thanksgiving, or New Year's.
Thank you, Your Honor.
All right, any questions? All right, I do. The police report says that you were chasing her with a knife,
No, ma'am.
and they say that there's a video of you chasing her with a knife.
No, ma'am, I did not chase her with a knife. I was simply scared running because there was 2 women after me, not only 1, 2.
All right,
Well, Judge, I don't know really what to make of this because lots of times we can say, well, the person has a mental illness, health, issues, they're on drugs. I don't know really what to make of this other than it's a one-time kind of incident thing.
Where's the video?
It's in the discovery.
Any objection to the court seeing the video? Just if you all have it, if I could see the video? Sure. Because she's saying self-defense, and I'm being told that there's a video that shows something differently.
Yes, Your Honor, but I think now she realizes it's definitely not self-defense. This is not a self-defense.
All right. So what I want to know is whether or not she was chasing somebody with a knife or not.
Probably I was scared, ma'am.
No, you said you were running from 2 women,
Yes, there were 2 women after me, ma'am.
but
And
the police report says that you were chasing the complainant with a knife. So were you chasing the complainant with a knife or no?
yes, to defend myself and run from, there was 2 women to defend.
If somebody's running away from you and you're chasing them with a knife, how are you defending yourself?
No, there were 2 women and one of them were after me.
Okay. All right. Well, we'll see the video, see what the video shows. All right. Gary Farmer. Court is calling 2023 CR 10501, State of Texas versus Gary Bernard Farmer. Can I have parties announced for the record for the state?
Anna Ochoa Nelson.
Defense?
Renee Munoz on behalf of Mr. Farmer.
Are you Mr. Farmer? You're gonna need to speak up.
Yes, sir.
Court reporter needs to hear, all right? You understand?
Yes.
All right, can you speak louder than that?
Yes, Your Honor.
All right, counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Mr. Farmer, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, let's pretend like you are outside with your friends. I know you're not whispering. So don't whisper in front of me because the court reporter cannot hear. You understand? And when I say she cannot hear, she can't hear whispering. It makes her job too difficult. So you need to speak at the level that I'm speaking at. You understand? All right, he's still whispering. Diana, can you hear?
Maybe if you move the microphone up a little, I think he's a very soft-spoken individual.
I hear bass in his voice.
Sorry.
All right, that's not trouble, that's bass. Although there was a rap song where they said, bang the bass and turn up the treble. I want you to bang the treble and turn up the bass, okay?
Yes, Your Honor.
All right, I'm showing you what's entitled Bill of Indictment. Did you review that Bill of Indictment with your attorney and did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, if we may.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We're proceeding on the lesser offense of assault, bodily injury, family member, Class A.
Any objection?
No objection.
Going to show you what's entitled Court Admonishments and Defendants Waivers and Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, family? That's a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Counsel, are you only applying for community supervision?
That's correct, Judge.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
that's correct, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Farmer, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, state is proceeding on the lesser included offense of assault, bodily injury, family. Punishment is to be assessed at 365 days in the Bexar County Jail. There's a $1,500 fine to be probated. State recommends community supervision. There's an affirmative finding of family violence. There's to be no contact with Marcel, Marcel, Washington, the BIPP, mental health evaluation and compliance. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of your plea?
Yes, Your Honor.
Defense is at the plea?
That's correct, Judge.
State is at the plea?
Yes, sir.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Next, I'm showing you outside the agreement. Outside the agreement, the state is requesting that your community supervision be for a term of 2 years and there be a TAP evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offer states Exhibit 1 with attachments.
No objection, Your Honor.
All right. And state, have you been in contact with the complainant about this offer?
We have, Your Honor.
All right. All right. You may continue to confer. Going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. My client's originally from Indiana. He moved here in about 2020. The last time he was receiving meds in Indiana was 2019. Unfortunately, Texas's resources for mental health aren't there compared to other states. He hasn't been set up with mental health services and meds. But in conferring with the state, I know that they're wanting him to be evaluated. He has been in custody for the last 125 days, Judge. As you can see, he's calm, docile, and he's willing and able to follow the probation. I did go over with him the BIP course and all the requirements of that, as well as the requirements of probation. He stated he would make all appointments. He knows that he can't live with his brother right now, Marcel. There's a no contact order. So he's able and willing to live with his aunt, Andrea Washington, lives here in San Antonio, to abide by the conditions of the court. We're asking, Judge, if you can do the mental health eval and tap out of custody. He's been in custody for 125 days now. People with mental illnesses in custody is generally not the most conducive environment for them to get a handle on their mental health, Judge. So he said he's willing and able to make all those appointments in order to get better mentally stable. So we're asking for those things, Judge, and for the court to respectfully follow the plea bargain agreement. There was a fight between brothers. It got a little heated. Things occurred that shouldn't have occurred, but he's remorseful for that, and he just wants the chance of this probation, Judge.
All right. So you moved from Indiana?
Yes, Your Honor.
Do you have family in Indiana?
Yes, Your Honor.
So what brought you to San Antonio?
Family?
Are you employed or receiving SSI?
No, Your Honor.
No to which one? No, you're not employed, and no, you're not receiving SSI?
Yes, Your Honor.
All right, when's the last time you were employed?
Last year, Your Honor.
All right. How do you support yourself?
I work.
Doing what?
Work, like warehouses.
Okay. How far did you go in school?
I completed high school.
So have you seen any doctors for your mental health?
Yes, Your Honor.
All right, and what's your diagnosis, if you know?
Schizophrenia.
Okay. And is this the first time you had an altercation with your brother?
No, Your Honor.
All right, what other altercations have you had with him?
It's like the same thing. We just turning evil sometimes.
I'm sorry, what?
We turning evil sometimes.
Okay.
So, Judge, just a little background for the court. Oh,
So
sorry.
just 1 second. But I read in the report that he's not verbal.
Yeah, he's like he has a mental illness, I guess. Yeah, and he just sometimes he just be turning evil, doing
All right, so on this occasion, what are you saying he did?
like he sometimes he's like normal, sit around and stuff, but sometimes he just black out, start hurting himself and like people around.
Okay, so during this altercation, what happened?
Like he was doing that, like hurting himself and people around him. So I be trying to stop him, but like it goes to a point where I like put my hands on him, or somebody in the house have to put their hands on him to make him sit down or something.
And how old is he?
He's 22. He's not on medicine, but I think he's supposed to be on medicine.
All right, and defense is saying that you have a place to stay with your aunt. Has anybody talked to the aunt? Does she want him stay? Have you talked to your aunt to ask her if you can stay there?
No.
Defense, have you talked to the aunt?
No, Your Honor. I spoke with him today. He said that would be an option because he's a family member living here. In terms of the brother, he does have, according to the mother, there's been nothing tendered in evidence about a disease called Lesch syndrome.
Well, if you're going to say that syndrome, you need to spell it.
I did have it, the paperwork on that, but you know, just to briefly just describe it, it's something that has to deal with like self-mutilation, where he kind of falls, he scrapes himself, he hits himself against the head, like the wall. And I think in this situation, I think the brother was doing those kind of things, and he was trying to get a handle on him, the brother, but it just kind of escalated from there, but he's aware of the no contact.
Dinah, that's LESCH-NYHAN syndrome.
Yes, yeah. Thank you for that, Judge. I don't know how to pronounce it either.
No problem. It's just when people are saying medical terms, then the court reporter will have to do research to find out how to spell it. So I always encourage people, when you're using medical terms, slow down and spell it.
Yes, yes. But yes, Judge, that's the situation. The brother unfortunately is afflicted with that, but I think that the brother does need treatment and help of his own, and it's kind of like he does things to, himself and other people that kind of can agitate, but, not to say that it was correct with how things progressed, but that, that's more or less why.
All right, do you have any children?
No, Your Honor.
All right, so what I can tell you, counsel, here's my concern with releasing him. He doesn't have a place to go. We're saying the aunt. I know there is a community court now,
Yes.
and I think that's with Judge Vera next door.
Yes.
So I'm going to have him in custody. If you bring back to the court, word from his aunt that she can stay there, then I'll release him. Otherwise, the evaluation for the mental health evaluation to place him on the mid caseload, that will be done, and the TAP evaluation will be done in custody. However, if you are able to bring to the court, that he has stable housing,
Yes.
that he has a doctor set up, then I will release him. But I can't just release him. I don't have anything showing that he's going to have his medications. Are you on medications?
No, Your Honor.
All right. So if he's schizophrenic, usually they're on medications. I don't want to interfere with any doctors that you may have. He needs to be set up with doctors, because otherwise what we're going to have is somebody who doesn't have a place to stay. People always say family will take them in, but sometimes you knock on family door and they're like, I don't want this problem. So if you give me that, I'll reconsider. But for now, he's going to be in custody until these issues are arranged. So, sir, if your attorney, he's an officer of the court, if he calls your aunt, talks to your aunt, and your aunt says you can stay with her, then I will allow you to be released. But for now, that's not going to happen. Okay.
Yes, Your Honor.
Yes, Your Honor. Thank you for communicating that, Judge. I appreciate it.
All right. So I'm finding you guilty. Going to sentence you to 1 year in the Bexar County Jail, suspended and probated for 2 years. There's a $1,500 fine that will be probated. There's to be no contact with Marcel Washington. State, I'm not really sure if this is a BIPP course issue that's needed here, but I know there's some anger management. Are you okay if I don't give him BIPP, but give him anger management instead? Defense, are you okay with me giving him anger management instead of BIPP?
Yes, Your Honor. Thank you.
All right. There'll be anger management. There's an affirmative finding of family violence. I'm going to want a MIC evaluation, a TAP evaluation, and both of those evaluations will take place in custody. There's to be regular reporting by Zoom or in person. I'm going to want monthly field visits. In probation, that will just be until he's set up with a case manager or he's set up with a mental health doctor. There's to be proof of employment or SSI within 45 days. There's to be no employment as a home healthcare provider or with minors. And there's to be no unsupervised contact with minors. In regards to the TAP evaluation, follow all TAP and mental health recommendations. If TAP suggests inpatient treatment, we're going to start first with outpatient treatment. Probation, is there anything else he needs?
I didn't hear anything about allergies.
Yes, thank you. Regular UAs.
And she wants to get her allergies.
No. Okay. All right. So, counsel, if you'll make sure you contact with community court, if you contact with them, even though he may not be eligible for their program, they may have contacts to get him housing and that type of a thing.
Okay. Yes, Judge, I know that sometimes it's hard for the specialty courts if it's not refiled as a misdemeanor to accept them because it's hard for them to track. But I can ask for the resources, surely.
Yes.
I'm gonna reach out to his aunts and then I'll update the court if I'm able to make contact. Oh, sorry. Yes, reach out to the aunts and make contact with her, and if he can stay there, we'll update the court as to that.
All right. And counsel, if for some reason they will take them as if this is refiled as a misdemeanor, you may want to talk to the state and see if they would object to a motion for new trial.
Okay.
All right. Mr. Foreman, is there anything you need from the court to be successful? Anything else you need? You'll come around.
Okay.
Yeah. Thank you.
Oh, there you go.
I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Oh, and I'm sorry, there's an affirmative finding of family violence. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Mr. Farmer, if there's anything that you need, please let probation know. If you feel as though probation is not addressing that issue, you can always come back to this court, okay?
Yes.
All right, good luck to you.
Thank you, Your Honor.
Thank you. Yes.
Do you have a number for your defense? Okay.
Are y'all ready on the case Annette Drago? Okay. Thank you. Yes. Okay. Okay. Okay.
Yeah, can I use your mouse?
Sure.
I remember exactly what.
Okay, let's pause it and I'll let you offer it into evidence.
Judge, and just to protect the record, if I could, I'm just gonna say that the court's requesting it, because since they're silent, so it doesn't look like they're
Sure.
not.
All right, we're gonna go back on the record. And cause number 2023 CR 7274, State of Texas versus Annette Drago. The court had requested a video and for the state.
Daniel Escobar for the state of Texas.
All right. And defense, this video was actually mentioned in the stipulations to the court. Defense, are you offering the video?
Yes, Your Honor.
All right. And so this will be marked as defense exhibit number 1. And the court will view the video. And I'm being told that the incident occurs at the halfway mark. All right. Counsel, any objection to the court fast forwarding?
No, Your Honor.
And who is your client, counsel?
Believe the lady with the hat.
Let me pause it. Mr. Drago,
Yes, ma'am.
what are you wearing in this video?
Um,
Are you the person in the black shorts?
no, ma'am.
Are you the person with the burgundy top with the blondish hair?
No, ma'am.
Are you the person in the gray shirt with blue jeans with the white hat?
I think so, yes.
And who is the person next to you?
The other lady, there were two ladies who approached me. I'm not sure. No, it wasn't. It was,
Okay.
something else.
So are you saying you're the person with the white hat with the check and the gray top and blue jeans with the white shoes?
I believe so, Your Honor. Not sure. I can't really see. Mm.
Start becoming like scuffle.
Okay.
Not melee. So,
I'll make sure you speak up because the court reporter, we're still on the record. Okay, let me, just 1 second.
See, she swung it.
Okay, let me Just one second.
See, she's swung it.
All right. All right. Any questions from the state? Yes. All right, defense.
Just a real brief argument, Your Honor.
Okay.
What we're asking you to grant Ms. Drago's application for deferred adjudication. You saw the video, Your Honor. In her mind, it was self-defense. I certainly understand the chase and all that kind of stuff. And she now understands how it is not self-defense. Nonetheless, Judge, she definitely takes responsibility for her actions. She's asking to be supervised by the court. I think she would benefit from some anger management and classes that help her deal with these kinds of situations and how to get herself out of these kinds of situations. So the long story short is, Your Honor, based upon her limited criminal history, her lack of drug use, the fact that she takes responsibility, we ask that you grant the application. Thank you.
Anything else you wish to say, Ms. Drago?
I just have some time to touch your heart and understand that you like the all I was asking is that if the Lord could hear me right now, he'd understand how much I repent of what happened that day. But it simply is just a self-defense in my mind, even though I know it's wrong.
Okay.
Thank you, Your Honor.
All right. Thank you so much. All right. So this is what the court is going to do. The court has heard all the evidence, and I want you to know that I internalize everything and I look at cases on an individual basis. The court is going to deny your application. Court will find you guilty. Court will sentence you to 3 years in the prison, give you credit for any time served. Take in consideration NITMAG number 714-465, NITMAG number 723973. There's an affirmative finding of a deadly weapon. Is there anything else with regards to sentencing?
No, Your Honor.
I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Counsel. Thank you. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Maybe excuse her.
Yes.
Thank you.
Do you need any?
Matthew Castro. Did you speak with his attorney, Norma? Matthew Castro? Yes, come forward. You were late for court today. Why?
Because when I got here, ma'am, I honestly didn't know how to come up here, so I had to ask people down there
What do you mean you didn't know how to come up here? You've been to this court before because you entered a plea.
with the other side, ma'am. I'm sorry.
There's only 187 district court. It's on the 4th floor. You cannot be late again. You understand?
Yes, ma'am. I won't have it again, Your Honor.
All right, we're recalling your case tomorrow for sentencing.
Yes, ma'am.
So Ms. Ferguson will give you the reset form. All right, thank you. All right. Court is calling 2023 CR 6843, State of Texas versus Latasha Jenkins. Can I have parties announced for the record for the state?
Seal language for the state.
Defense?
Rafael Leal for Latasha Jenkins.
And are you Ms. Jenkins?
Yes, ma'am.
You entered a plea of no contest on December 5th. According to the plea bargaining agreement, the state is silent on your application. They're taking in consideration 2022 CR 3280. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor. I call Andre Carruthers to stand.
All right. Carruthers? All right, Mr. Carruthers, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Andre Carruthers.
All right, defense?
Yes, Your Honor. How do you spell your last name?
Corothes.
And what is the type of your relationship to Latasha Jenkins?
A boyfriend.
Right? And are you the complainant in this case?
Yes, sir.
And and this is the incident that occurred May 5th, 2023, is that right?
Yes, sir.
Okay, and you understand the accusation and the offense that Ms.
Just 1 second
Jenkins.
off the record for a moment. Excuse me. If y'all could move down to this end. All right, you may continue, counsel.
Thank you. And you know the charge that Ms. Jenkins is facing?
Yes, sir.
Okay, and it's an aggravated assault with a deadly weapon.
Yes, sir.
And she has applied for the deferred adjudication, which means a type of probation that there will be no conviction if she follows the guidelines and does not commit any other offenses or comes up positive with drugs.
Yes, sir.
You understand that?
Yes, sir.
And are you opposed to Ms. Jenkins getting probation?
Am I against it?
Are you against it?
No, sir.
Okay, so you are in support of that?
Yes, sir.
And there is also a provision perhaps that the court may impose that there will be no contact with you if she's granted probation. Are you aware of that?
Yes, I was told.
And do you oppose the contact order?
Yeah.
And do you oppose no injurious or hazardous contact? Are you in favor of that? Which means the two of you or she cannot have or give you any kind of injury or be a hazard to your health.
Yes, sir.
You think that would be okay with you?
Yes, sir.
Okay. And concerning the incident, what type of injury did you receive?
It was like a scratch.
Scratch?
It was like a scratch.
So there was nothing else besides that? Okay. And were you two on drugs at the time?
Yes, sir.
What type of drugs were you doing?
Yeah.
And she cannot be having, if you two are in contact with each other, she cannot be having or be using drugs. Would you be able to support that given that you're also a drug user?
Yes.
Are you still using
Against
drugs?
it? No, sir.
I'm sorry, I can't hear you.
Are you still using drugs? Yes or no?
No, ma'am.
All right, pass away.
All right, any questions?
No question, John.
All right, so I see here that she stabbed your bag several times. No. According to the police report, it says that she started cutting up your bag.
Did I know it?
Okay. All right, thank you.
I call Latasha Jenkins to stand.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Sure.
All right, you can lower your hand, state your name for the record.
Latasha Jenkins.
All right, defense?
Ms. Jenkins, you applied for a type of probation known as deferred adjudication probation, is that correct?
Yes,
And that is a type of probation that if you do not comply with the requirements of that community supervision, deferred adjudication, the judge has the full range, if you violate a condition, the full range of punishment, anywhere from as low as 2 or up to 20 years. Are you aware of that?
yes,
Okay, do you intend to abide by the conditions of probation that the court may impose?
yes, sir.
And why do you think that is the case?
Because I'm changing my life. I sat in Bear County for almost a year and I completed successfully classes, got certificates. I got recommendations from the teachers in unlock programs for the outside community to better be successful with my mental health and my substance abuse and me, period.
And the programs that you completed, are those included in Defense Exhibit 1? Is that right? Do you recognize Exhibit 1?
Yes, sir.
And Exhibit 1 consists of 8 pages of certificates covering the different programs that you attended?
Yes, sir.
And that includes anger management, is that correct?
Yes, sir.
And also therapy groups
Yes, sir.
and Microsoft Word
Yes, sir.
and Excel.
Yes, sir.
And Exhibit number 2, what is that?
The letter to the judge Boyd from Lisa Rodriguez, the unlock program.
Okay, and what type of program is the online program?
Any classes that you need that the court orders for you, they help you with the fees. It's for continuing care. It's a re-entry program. They help you with anything that you need to help me get back on my SSI, get my SSI started again, and to get me with a part-time job, whatever SSI allows me to work outside of SSI.
If you work, is that they help you to reintegrate yourself to society?
Yes.
Okay. I offered Exhibit 1 and Exhibit 2 for.
Any objection?
No, Your Honor. State has reviewed these.
All right, then Defense Exhibit 1. And Defense Exhibit number 2 is admitted into evidence.
Now, prior to this incident, were you on SSI?
Yes.
And were you also working part-time?
Yes.
And what do you intend to do? What are your plans if the judge were to grant you a deferred invitation?
Get back on my SSI and continue a part-time job that SSI allowed you to work and maintain my mental health.
What type of mental health illness do you suffer from?
Bipolar and PTSD.
And were you on medication at the time of this incident?
No.
Okay, and are you on medication now?
Yes.
Okay. And do you have a place to stay?
Yes.
If you were granted probation?
Yes.
And where would that be?
My brother's house.
And does he know that that's what you're planning to live?
Yes, he's been supportive for me since I've been in the Bear County.
Do you have any children?
No.
Any questions?
No, Your Honor.
All right, why did you cut your boyfriend with a knife?
We were into an altercation and I didn't intentionally do it. When I pulled it out, it was like a scratch that was gone like within maybe minutes.
All right, why were you cutting up his bag?
I don't remember cutting his bag up. I don't remember that at all, cutting the bag.
All right. Why have you not been successful on previous probations? Because I see that you've been on probation in Des Moines, Iowa.
Yes. I was in Des Moines, Iowa. My mother died. My husband went to federal prison. My brother left state. I was the only one there. I had no support system there. And I was going house to house. I couldn't maintain employment.
What is the escape?
Oh, it wasn't escape. It was dropped from escape. I left from the place that they sent me to after I got out of jail. It was a involuntary absence. That's what they dropped it.
No, and where did they place you after you were released from custody?
It was like a halfway house.
Okay, and you left without permission?
On Sunday.
Yeah, and then, so that's from 2007. Then 2011, you were placed on probation again and revoked, and all of this is out of Des Moines, Iowa.
Yes.
Then in Knoxville, Illinois, you were revoked from probation there as well.
Knoxville, Iowa.
No, it says Knoxville, Illinois, Marion County.
Yeah, that's Iowa.
Okay. And then Hamilton County, Illinois.
Iowa. I don't know why they put Illinois.
Okay. All right. And then Dallas County.
Yeah, that's Iowa too. I was just a bad area. Since I left there, I have been so much better. Like I was like, my life was not great there at all. I had no support there. Like I said, like my mother died, my brother left town, my husband went to federal prison. My life was just not great there. That's why I left there and came up here and lived.
All right.
And
Well,
started my life.
I've read defense, I've read all your exhibits, and I've read your letter from Ms. Rodriguez. I appreciate you presenting these to me because it gives me a chance to know the person that's before me. And I also am taking in consideration the testimony of Mr. Carruthers. However, I don't think you'll be a good candidate for probation. So I'm going to find you guilty. There's to be no contact with Andre Carruthers, Tiffany Sansom, Sansom. There's affirmative finding of family violence, taking in consideration 2022 CR 3280. I'll sentence you to 3 years in the prison, give you credit for any time served. I've actually given you less than what was requested. And there's also an affirmative finding of a deadly weapon. Going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargaining agreement, because I've actually given you less than what you bargained for, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and also an affirmative finding of deadly weapon and a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Ms. Jenkins, good luck to you, okay?
And, is it possible if I get my 2 for 1?
You'll have to, here's what people don't understand. 2 for 1, 3 for 1. The court is not in charge with that. It's whatever institution you're at, they're in charge of what credit they give you. What I can tell you, you will at least be receiving time for every day that you've been in jail. And whether they want to give you good time credit or not, that's dependent on the institution. But if there's an issue, for example, let's say hypothetically you've been in jail for 50 days. If you feel like you're not getting credit for those entire 50 days, then your attorney can come back. But if you want 100 days or 150 days, that's something with the institution. It's not something that I can give you. All right, good luck to you. Diana.